Good afternoon. My name is Tom Curvin, and I'd like to welcome you to the Sutherland Webcast today, Insurance Litigation Trends to Watch in 2016. I'm joined today by my Sutherland litigation colleagues Kim Kochis, Philip Stano, Louis Wiener, Valerie Sanders, and Wilson Barmeyer. This is the latest in a series of webcasts that we've devoted to litigation issues faced by insurance and financial services companies. We'd like to welcome back those of you who've joined us for our earlier programs, and we'd like to welcome those of you who are new to our series. If you would like to receive CLE credit for this webinar, please download the CLE sign-in sheet and evaluation form that you can see on your computer and follow the instructions to submit that paperwork. We'll be announcing a CLE code later in the program. And if you have any questions during the webcast, please submit them via the Ask a Question text box on your computer, and we will address those during the program or at the end. Litigation remains a fact of life for insurers and other financial services providers. Today's program will be a rather fast-paced discussion of some of the litigation developments that we are watching in 2016, and our topics are going to include cost of insurance on the life side of the insurance sector, data breach class actions, big data analytics and predictive modeling, class action developments, including no injury class actions, trial by formula, and the ascertainability question, retirement plan litigation, including revenue sharing, proprietary product, and stable value fund issues, the sharing economy, autonomous vehicle technology, and its implications for insurance, the Federal Telephone Consumer Protection Act, class actions against insurance companies, and recent changes to the discovery rules now applicable in federal courts in the United States. And with that, we're going to begin our discussion with an update of cost of insurance litigations from Phil Stano.
Thanks, Tom. Good morning, everyone, or good afternoon, I should say. Welcome to the webinar. I'm going to talk about cost of insurance litigation, and I'm going to talk about, in the brief time that I have, some selected cases that I think will lay out the parameters of the issues, and we'll talk about a second front that's being opened in cost of insurance litigation. The cost of insurance litigation is something that's been expected for a long time, and it has been happening over the past couple of years, and it should be picking up based on the interest rate environment that we're in. And it seems like interest rates have been low for forever, and insurers are crediting higher amounts to policies than they're earning on their investments or starting to earn on their investments. Policyholders are in no mood for a rate increase, but that's going to happen. Policyholders are upset with the low interest rates that they're earning, but that's for that very same reason insurers are going to be having rate increases based on the low interest rates on their investments. In fact, given the recent happenings in China, given the stock market volatility, the oil prices being in the tank, in some parts of the world there are negative interest rates being offered by in countries where entities are parking their money with the government and actually paying for the price of doing that. So interest rates will be low for the foreseeable future, it seems, and the cost of insurance litigation will rise as a result of that. I want to talk about just a few cases because in the limited time I have. And the first case is the Hayes versus Hartford Life case. It's fairly unremarkable in terms of what the litigation was about. The policyholder, who happened to be an attorney, was receiving annual reports on his universal life policy. His values were going down as the interest credited went down. He was given numerous notices of rate increases. He paid some rate increases. Eventually, he got tired of it and stopped. His policy lapsed, and he sued. And the court granted summary judgment to Hartford, basically saying, you know, the plaintiff had adequate notice. He knew what was happening. He didn't. He's now ineligible to renew his policy, or he didn't show evidence of insurability. And so they ruled on summary judgment in favor of Hartford. The reason that I found the case interesting is how the court described universal life insurance. And it compares a universal life policy to a mobile home on land, and where the owner of the mobile home is earning equity in the mobile home as they make house payments, but they're renting the property where the mobile home is sitting, and the rent increases could go up. And to me, that was a fairly apt analogy of universal life, and it shows how courts address the complex issues of universal life. when they handle these cases. The court had an interesting quote, which I didn't put in the slides, but it's in the opinion. They quoted a website, and they said, quote, "Universal life is so flexible that it can be a treacherous policy or an excellent policy," close quote. And that pretty much sums it up. And that's one reason why we're having such dramatic differing opinions by the courts on universal life policies with rate increases. The rate increases come through under the cost of insurance in the provision of the policy. And the question is, what's included in cost of insurance? Insurers position that it includes mortality and non-mortality factors, which are listed on the slide, risk, expenses, profits, and that the policies that these cases are looking at usually have some general provisions that are found in most of the opinions. Some policies would talk about a, quote, expectation of future mortality experience, close quote, as one of the factors for rate increases. Others talk about cost of insurance being based on certain policy provisions. And then other policies have a maximum guaranteed cost of insurance rate provision. All of these provisions are very relevant to the court's outcome when they analyze the case. And let's look at some typical rulings. Before we do that, let's look at the plaintiff's position. We've seen the insurer's position that based on can mean provisions including issue age, sex, face amount, and premium class. The plaintiff's position is that based on when the policy says that cost of insurance is based on certain enumerated factors, that those factors are all the factors that the court or that the company can consider when they have a rate increase. They interpret based on to mean basically based solely on. And they view the phrase based on as an exclusive list of factors, and it's a limitation or qualifier on considering factors not specifically stated in the policy. And they argue that that's how a reasonable policyholder would view that, and therefore if the insurance company views it differently, then the policy is naturally ambiguous, and therefore it should be construed against the insurer. And since the policy is construed in favor of the insured, and if the insurer considers factors beyond those factors enumerated in the policy, then there's been a breach of contract. So a fairly simple, straightforward legal theory that's put forth by the plaintiffs, and they've done it with mixed results, but good results in a number of cases. Let's look at the decisions favorable to the insurers first, real quickly. You have the Seventh Circuit, the only appellate court to rule on this issue. There are two decisions. Both decisions said that the based on specified factors provision of the policy does not mean that the rate will be based exclusively on those factors. They each use different analogies. I quote the cake analogy in the Lincoln benefit case. The Midland National Court also had a similar analogy. They used the analogy of a shipper charging its rates based on size and weight and the destination of the package, but yet, of course, they would also consider unstated factors such as wages and profit and competitor charges. That's sort of the analysis that's given. The court also looked at the maximum rate in the policy provision, and they said as long as the insurer had a rate increase that did not exceed the maximum rate, then the rate by nature could not be excessive because it's less than the guaranteed maximum rate in the policy. So that's an important factor you want to look at when you look at your COI rate increase issues. Now then there are the decisions unfavorable to the insurers. I'm going to speed up pretty quickly because of the shortness of time. Yulee versus Conseco, the rate was to be based on the expectation of future mortality experience. Here the rate was based on the fact that the persistency rates were high. In other words, the lapse rates were lower than anticipated, and they increased the rates for that reason. Typically when lapse rates are lower than anticipated, it's good for the company initially because they collect more premium than they expected because they thought more people would be letting their policies lapse. It's actually negative in the long run because those folks who didn't let their policies lapse as was expected didn't let them lapse because of their poor health risks, and they're keeping their policies for that reason, and therefore they have higher claims down the road. The court said it doesn't matter. If you look at the policy provision, it's based on the expectation as to future mortality experience. That's what the rates increases is based on. You're looking at lapse rates or persistency rates irrelevant to mortality experience. And so they ruled in favor of the plaintiff. The same with the Fleischer decision, which rejected the Noreen decision and the Seventh Circuit decision we just talked about. The latest decision is the Lincoln National decision out of the Indiana Appellate Court. It's presently before the Indiana Supreme Court. The parties are going to settle. The adverse Court of Appeals ruling from the Indiana Appellate Court is there, and it's the latest decision that's hurtful to the industry. I want to move on because time is growing short. Looking at settlements, the initial round, first generation of settlements, was a full rate rollback of the rate increases. And since then, there have been other settlements where there have been partial rate rollbacks. I mentioned the Conseco decision here where you had a 50% rollback for 5 years and a 30% rollback thereafter. So when you factor in the cost of should you seek a rate increase, what is my litigation exposure, what is the outcome, this is something you might want to think about whether you win or lose, is would there be a partial rollback only. The second front that I mentioned earlier when I began discussing this issue is the actions by institutional investors to seek regulatory involvement on these rate increases. The Institutional Longevity Markets Association last year wrote 9 states and complained about 5 companies' rate increases. Some of you may be on this call. And what they're trying to do is, frankly, it's a good strategy. It's a smart strategy. They're trying to get the regulators to take action prior to suit. They're trying to get some state-created, state-sponsored discovery and have the regulators take action against the companies, maybe make findings that the companies have acted improperly, and then have a suit that has some natural discovery that's favorable to the plaintiff. And these are some of the factors you need to be looking at when you look at your cost of insurance rate situation. If you're considering a rate increase, you basically want to do a deep dive with your actuaries. You need to make sure all information is protected. You need to look at not only the policy language, but the point of sale materials. You need to look at your rate memorandums filed with the regulators. You need to especially look at your disclosures filed with your regulators. Look at the factors. Look at your original pricing methodology. Look at the non-guaranteed elements. How are they discussed, if at all, with the regulators? You need to make sure you have all that covered because all that will come out. And if you're going to do a cost of insurance rate increase, you need to line up all different practices that are involved in this rate increase, regulatory, GR, actuarial, marketing, legal, so that when you engage in this rate increase, all of these areas are going to be impacted, and you need to be prepared. I don't know how much time I have left. I think I better stop now in the interest of discretion and go to the next speaker. Tom, I think that might be
Thanks.
you.
So our next topic we're going to shift to is big data, data breach litigation, data analytics, and predictive modeling. The data breach litigation never seems to be out of the papers. Just since 2005, and this is according to publicly available information, there have been over 640 publicly reported data breaches affecting providers in the insurance and financial services sector. There were 39 of those that have been publicly reported since we gave this presentation last year. So since January 2015, there have been about 40 more publicly reported data breaches involving insurance and financial services providers. Targets of some of these recent data breaches include health insurers. They seem to be the most common target of at least publicly reported data breaches. Retirement plan service providers, insurance brokers, and even the insurance services office itself was the victim of a data breach in 2015. On the litigation front, data breach litigation continues apace. A couple of the key issues that you see in the data breach litigation is the issues of injury standing to sue. That is, once a data breach has occurred, who among the affected consumers or victims is actually able to bring and prosecute the class actions that ensue from most data breaches. This issue continues to be a key focus of data breach class action litigation. And the issue really is there's a spectrum of harm that flows from the typical data breach involving consumer information. You've got people who've suffered tangible financial loss from identity theft. Their personal information, for example, their credit card number has been hacked and someone else actually uses it. You move from that to people whose identities have been stolen in whole or part. Their personal information has actually been accessed, but they haven't suffered any actual financial loss yet. Their information may have been compromised or accessed, but no one has actually used it yet. And then at the other end of the spectrum, you've had a hacking, and there is your information was made available to a third party, but there's no proof that the information has actually been accessed yet, and so that's the other end of the spectrum. It's that third category of cases that really continues to vex the courts. The most common scenario is a retailer announces that, for example, information about its credit card customers was compromised, has been accessed, but or was made available, was hacked, was the victim of malware or spyware or something like that. But there's no firm indication yet that that particular consumer's information was used. And courts are frankly struggling with at what point do consumers in that situation actually have standing to sue, have suffered a concrete enough injury that they're able to prosecute class action cases. There was a significant decision, the Neiman Marcus case from the 7th Circuit in 2015, and there Neiman Marcus had its credit card database was accessed during the holiday season. About 9,000 customers actually had their identities, their credit card numbers accessed and used. There were fraudulent charges for those folks. They obviously had standing. But there were 350,000 other customers whose credit card numbers and other personal information were potentially accessed, but they couldn't yet show that their information had actually been used. And the 7th Circuit, in contrast to some other courts around the country, held that as to that second category of people, the data breach had occurred and that there was an objectively reasonable likelihood that those customers' personal data would be misused. And the court even emphasized that, look, that's why hackers go to the trouble of hacking a database like that. And I think the court viewed that it was reasonable to expect that those people were certainly had a very real risk of having their information misused, and so they were granted standing. A related issue is of interest to, and particularly the P&C side of the business, is when there has been a data breach, is there insurance coverage for the cost of remedying the breach, perhaps the cost of handling class action litigation. There was a significant case. There's a significant case pending in the federal 4th Circuit right now dealing with that issue. And again, the issue is similar to in the consumer cases when information has been compromised, but it hasn't actually been used to the detriment of consumers yet. Does that constitute enough of an injury or a publication that would trigger coverage under CGL policies? That issue continues to divide lower courts and will continue to be litigated in the foreseeable future, particularly when there are data breaches of entities who have traditional CGL coverage as opposed to some of the newer cyber-specific policies. Shifting gears, so that's how customer information can be misused, but insurers are using big data and particularly consumer behavior in a lot of creative ways, both in underwriting, pricing, policy and force management, and claim handling. And there were significant regulatory developments in particular and litigation developments in 2015 that continue into 2016 in this area, and particularly with this issue of what's been called price optimization. This is an issue that is getting a lot of regulatory attention on the personal lines side, with particularly personal lines auto insurance. And the practice, as it's described by regulators, a lot of state regulators and consumer groups, is broadly defined as including in your premium calculation factors such as price elasticity. In other words, how sensitive will consumers be to price increases, and at what point will an increase an increase in a premium likely drive a consumer away to either purchase elsewhere or cancel or non-renew. The National Association of Insurance Commissioners has focused a lot of attention on this in 2015 and published a white paper with some guidance and suggestions in November 2015. So far, 20 state insurance commissioners have weighed in on this issue with some form of guidance on it, and 18 states have issued bulletins or directives prohibiting price optimization as they view it. And this continues to be a focus of regulatory attention. In addition, 2015 saw the first class actions challenging this practice. There are class actions brought in California and Washington. The Washington one was dismissed early on, but 2 of those cases are pending in California, and there consumers filed class actions alleging that using price optimization in pricing personal lines auto policies violated California's unfair competition law, violated state false advertising laws, and constituted common law and unjust enrichment. In both those cases, insurers have moved to dismiss, relying heavily on the filed rate doctrine. The idea is that, look, these class actions are really challenging rate making, and that is within the province of the insurance commissioner, that you're challenging rates that have been rating plans that have been filed and approved, and it's an impermissible use of the court system to do that. Most recently, in late January of this year, a state trial court denied a motion to dismiss brought by the insurance company based on the filed rate doctrine, held that the claims at issue were not barred by the filed rate doctrine, but interestingly did agree with the insurer that the decision, or that the questions should, in the first instance, go to the insurance commissioner. So although the court denied the motion to dismiss, the court did grant a motion to stay the case pending proceedings before the California Insurance Commissioner. The court was sufficiently convinced that the real issue was whether or not prohibited factors were in fact included in the rate filing or not. There's a factual dispute over that, and the court said that that's the sort of issue that really should go to the insurance commissioner. So we'll be watching that in 2015 and expect further developments in that area. Next topic we want to cover is class action developments that we're watching in 2016, and for that we're going to turn it over to Valerie Sanders.
Thanks, Tom. Honestly, they might better be described as incipient developments in the class action arena, because we're going to take a brief overview of 2 cases currently before the Supreme Court, and then an issue which may be making its way there. None of these is an insurance case, but each of them could have some ramifications for the industry depending how the case comes out. So the first case we'll talk about, which was argued, and one caveat with these 2 cases that are before the Supreme Court, the Tyson Foods case and the Spokio case, both were argued in November. And so depending on what happens following the death of Justice Scalia, these could be re-argued and reconsidered then following the appointment of a new justice. The alternative would be, to the extent Justice Scalia's vote was going to be dispositive, 4-4 split and an affirmance. So we're going to talk about their having been argued in November, but there is a little bit of uncertainty there as to whether there may be another argument. With that said, the first case, Tyson Foods, which we've spoken about previously, is an FLSA, an employment case coming from the 8th Circuit. The claim was that these workers at a Tyson plant were not being compensated for overtime work. There were issues of doffing and donning time, cleaning equipment, things of that nature. The plaintiff's experts calculated some average times for various jobs and things that happened, and really conceded that actual times could vary, and some employees weren't even going to end up with overtime. The district court, on that record, certified a B3 class before Walmart v. Dukes, and then denied a motion to decertify following Walmart, phrasing the question, as you can see there on the slide, as distinguishable from Dukes in that this case, the district court said, involved a company-wide compensation policy that is applied uniformly. So that's what the district court said. The case then went to trial. There was a jury verdict in favor of the class of about $3 million based on the plaintiff's expert's testimony. Interestingly, it was lower than the number ultimately suggested by the expert's testimony, but it had been based on that averaging analysis. The case goes to the Eighth Circuit, which finds no abuse of discretion in the certification of the class. But what the Eighth Circuit pointed out was that there was a 1946 Supreme Court case in the FLSA arena which comes into play in conjunction with Rule 23. They say here, as you can see on the slide, true, applying expert testimony to generate answers for individual overtime claims did require inference, but this was allowable under Anderson versus Mount Clemens Pottery, which basically shifts the burden to the employer where the employer has not kept detailed enough records to obviate the need for that kind of averaging. That's what the Eighth Circuit said. Cert was granted in June. The cert questions as posed don't really tee up, arguably, this issue of the inference and whether it's permissible just in the FLSA context. Rather, they speak to broader issues of whether class or collective action can be certified when there's going to be statistical averaging, presuming everyone identical, and then the second question, whether the class can contain plaintiffs with no injury. So that's how it went up. It was argued on November 10th, and reading the tea leaves from the arguments, and I think there's something of a consensus among commentators that this may come out on those more narrow FLSA grounds. However, it could certainly come out on grounds that would affect class actions more broadly in terms of, for example, endorsing the use of averaging, which would have a wider impact. The second case, which was also argued in November, is the Spokio case, to which Tom alluded in the data breach discussion. This was a case, actually, which was pled as a class action, has been pled as a class action, but has not been certified yet. The case is at the Supreme Court following, first, a dismissal of the plaintiff's complaint. So this is Spokio, and interestingly, this plaintiff is not really in the extreme category of people that Tom described, where maybe something's happened with his data. It's undisputed that Spokio, which publishes sort of directory information, had published information about this guy which was inaccurate. There's some debate as to whether it was objectively unfavorable, but it was inaccurate. So something was published about him, but that's about all he said in his complaint. He didn't say he was denied employment or that any specific bad thing had happened or that he'd lost money as a result. So the defendant moved to dismiss for lack of standing, lack of subject matter jurisdiction. The district court dismissed the case on those grounds. The Ninth Circuit reversed that dismissal, saying, as we see here, yeah, the allegations of injury were sparse, but when, as here, the statutory cause of action, which here was under the Fair Credit Reporting Act, does not require proof of actual damages, a plaintiff can suffer a violation of the statutory right without suffering actual damages. Then went on to say, as sort of a safety net, and the interests protected by the statute here are sufficiently concrete and particularized that Congress can elevate them. So that's what the Ninth Circuit said, and then the case goes to the Supreme Court. It was granted in April on the question, which arguably is a little circular, whether Congress may confer Article III standing upon a plaintiff who suffers no concrete harm. So assuming there in the question there is no concrete harm, which might be a little different than actual damages. It was argued in November 2, and here, similarly to Tyson, we could get we could get an Article III decision which just says, and this, you could pick some of this up in the oral argument, look, it seems reasonable, objectively reasonable, that Congress would say having inaccurate stuff put out there is an injury, regardless of whether you were denied employment or arrested or anything else bad happened. It may be fine in and of itself. And that goes to the Article III question, which is really what went up. I think we can see down the road, if this case proceeds, it has been pled as a class action. So to the extent there are folks out there who can plead more technical violations of the reporting statutes and maybe not the actual dissemination of false information, one can see that coming up in the Rule 23 context. But right now, all the court's got before it is the dismissal of this one plaintiff, and so we'll see how that comes out. So those are the two cases that are already in the Supreme Court. The one other thing I'd like to mention is a bunch of cases which are sort of bubbling up as there are 2 cert petitions filed. We'll see if those are granted. And these are cases that have to do with the ascertainability requirement in class actions. So ascertainability, of course, is the exercise of determining who is in the class, or the putative class, as the plaintiffs have defined it. The debate over this arguably really started or became heated with the Third Circuit's decision in Carrera, where the Third Circuit said, look, not only do you need an objective class definition, that's not just everyone who was harmed or something circular, you also need to think about, quote, administrative feasibility. Can the objective definition can those folks be identified in an administratively feasible way from the defendant's records? So the Third Circuit in putting sort of a practicality requirement there. I'm actually going to skip EQT and Carhu for a moment just to go down to Ricos and Mullins. Now, those are the cases where cert petitions are currently pending, one from the Sixth Circuit and one from the Seventh, both affirming certification and rejecting a defendant's argument that under Carrera, the certification wouldn't be administratively, or the identification of class members wouldn't be administratively feasible. So Ricos and Mullins from the Sixth and Seventh Circuits both come out pretty strongly and say, we're not following Carrera. And the Seventh Circuit in Mullins actually went so far as to say, we just think that's a wrong reading of Rule 23 because if there's a problem with going through the weeds to identify folks, that can be managed under the superiority requirement sort of later in the class cert analysis, not up front as to ascertainability. So I skipped over EQT and Carhu to return to them just to explain why they're on the slide, is arguably those 2 cases from the 4th and 11th Circuit have followed the stricter Carrera requirement. I say arguably because in EQT, the 4th Circuit did refer to administrative barriers, but then went on to sort of say they weren't sure they were that bad in that case, as a matter of fact. And in Carhu, that's an unpublished decision from the 11th Circuit, and importantly, there's a dissent from Judge Martin there, which says, I believe it's a concurrence, actually, but she dissents on the major issue of self-identification for whether plaintiffs can simply submit affidavits to say that they are class members, they did buy the product, et cetera. So certainly the Third Circuit and the Sixth and Seventh are at odds here. The Sixth and Seventh have pending cert petitions, and we'll see how that comes out.
Well, a fertile area for class action litigation, including quite recently, has been the area of retirement plans, and Wilson Barmeyer is going to talk to us a little bit about that topic.
Thank you, Tom. This is ERISA litigation of the class action variety against life insurance companies involving retirement plans. We saw a lot of new developments in this area in 2015, and we expect it to remain very active in 2016. In particular, some of the plaintiffs' firms that have been active in this area have closed off some older cases and are now engaged in filing some new cases in late 2015 and early 2016. 3 new cases filed just this week, though not all of those are against insurance companies. There have been several varietals of this litigation. These theories are now beginning to merge and blend as the developments in the cases steer the plaintiff's counsel and as the plaintiff's counsel learn from each other and also come up with new theories. This has traditionally involved either excessive fee cases against plan sponsors or cases brought by plans against insurance service providers. Those cases brought by classes of plans. We've now seen cases involving proprietary products used by insurance companies in their own 401k plans, and most recently a number of cases filed against life insurers involving the stable value funds that are offered as part of retirement plans. In the traditional excessive fee plan sponsor cases, those continue to be filed, and there have been a number of recent filings. The biggest substantive development in 2015 was the Supreme Court's decision in Tibble versus Edison, which did not get to the merits of the alleged ERISA fiduciary breaches, but instead focused on the statute of limitations. The decision gives somewhat of a boost to the plaintiff's counsel in these cases and could spur some additional litigation. The court held that an ERISA fiduciary's continuing duty to monitor investment means that a breach claim is timely if filed within 6 years of the failure to monitor. So this removes an arrow from the quiver of defendants who are trying to limit the scope of these suits or dispose of the suits entirely. Traditionally, the cases against life insurers have been of the service provider varietal. This typically involves a class of plans bringing claims against a life insurance company that's providing services to retirement plans. The focus of these cases has traditionally been on receipt of revenue sharing payments. Some recent developments here, the granddaddy of this type of case, Haddock versus Nationwide, was settled last year after more than a decade of litigation. There have been some new cases filed. These cases historically also involve challenges to the disclosure of fees, but we expect to see less of that since the effective date of Department of Labor regulations that governs the disclosure of compensation. And even though I'm saying that, they're actually one of the cases filed this week involves a claim involving failure to properly disclose fees and claims that the service provider did not sufficiently comply with the DOL regulations, and that's a new allegation that I don't think we've seen in prior cases. Life insurance companies have also been involved in ERISA challenges to their use of proprietary funds for their own retirement plans. These cases have been brought by participants in the financial institutions' plans. Defendants have been both life insurance companies, as I mentioned, and also some banks. One of these cases was settled for more than $20 million in 2015, and we've seen some recent filings as well. Allegations typically involve breaches of fiduciary duty, prohibited transaction. These cases represent somewhat of a blending of themes of the plan sponsor cases and the service provider cases, because here the plan sponsor is itself a service provider, and the theme of these cases is that the financial institution is capturing fees for its own products by having its own plan offer those products to participants of its own plan. So something like a self-dealing type of a theme. The most recent theme developing in this genre of litigation are cases filed challenging stable value funds offered in connection with retirement plans. There have been several cases filed against insurance companies in late 2015. Like the other service provider cases, these are typically brought on behalf of a class of plans alleging allegations under ERISA, typically alleging that the insurance company is a fiduciary in managing the assets of the stable value fund and focusing on the way the compensation has been set for the fund, alleging that the spread is excessive and therefore the expense charges have been excessive in the compensation that the insurance company is receiving as part of this investment. There have been several different varieties of stable value fund litigation. In some cases involving participants, the allegations have been either that the stable value fund is underperforming because the investments weren't aggressive enough, and then some other cases alleging that the failure to include a stable value fund was imprudent because the stable value fund would have had higher returns than a money market fund. So a lot of different allegations against service providers and plan sponsors based on the use of stable value funds. Takeaway themes, there's a lot of different developments in the area and much too many to cover here, but I think the takeaway themes would be that we have seen a number of cases filed in the last couple of months, late 2015, early 2016, and so we expect this to be a very active area. There are motions pending in a number of the cases, so we would also expect some rulings to be coming down this year. And just as a general point, the themes of these litigations are blending, where the cases against plan sponsors alleging excessive fees are also now including allegations about the stable value fund. The traditional cases brought by classes of plans against service providers have merged into classes of plans bringing claims about stable value funds or claims against financial service providers being brought by participants because of the proprietary products being used in the plan. So just a lot of turning around of the themes, and we expect a lot of activity in this area going forward.
Thanks,
Tom?
Wilson. Thanks. Before we go to our next topic, we have some CLE instructions. For those of you who would like to receive CLE credit for the webinar, the confirmation code is TRENDS, capital T, lowercase RENDS. Please use that code for the sign-in sheet that you can download from your viewing console. All right, shifting gears, we're going to turn to developments in particular in the auto insurance sector, the sharing economy and autonomous vehicle technology, and Kim Kochis is going to tell us about this area.
Thanks, Tom. I'm excited to talk to everyone today, however briefly, about two emerging areas, namely the sharing economy and autonomous technology. We think these are important areas for insurers to be watching because these are emerging and presenting both new risks but also new opportunities for insurers. Let's start with the sharing economy. What do I mean by the sharing economy? I'm referring to services such as Airbnb, HomeAway, Uber, and Lyft, and I think we'll see more emerging areas and types of shared economies coming out in 2016. Let's just talk about Airbnb for a moment. We saw exceptional growth in 2015 and expect this growth to continue. Airbnb saw more than 1 million rooms available in 192 countries in 2015. And with this growth comes issues, particularly regulatory and compliance issues. There's states and cities where rules differ. Even in counties, side-by-side counties, the rules can differ. This presents licensing issues, and it's even illegal in certain states and cities. So New York City is one of Airbnb's largest markets, and we saw a report by the AG's office here in New York in October 2014 called Airbnb in the City, that 72% of all Airbnb reservations violated New York law. This is an incredible number, and I think we're going to continue to see regulation emerge in 2016. Similarly, Uber and Lyft saw exponential growth in 2015, and Uber recently announced in New York City fairly dramatic rate cuts that will make it actually cheaper to use Uber than yellow cabs in a lot of areas in New York. This is going to lead to a lot increased use of Uber, at least in New York City. And so one of the risk areas in this area is failure to regulate employees. The job flexibility is great, but it comes with somewhat of a lack of supervision. For example, do you want to be, with respect to ride sharing, do you want to be in a car where a driver's been driving for 20 hours straight? To combat this, Uber recently announced that it would cap drivers to 12 hours a day in New York City, but we expect we'll see continued regulation in that area as well. Another risk with the shared economy is adequate screening. There's been some sensational news articles about crime, but there are also less sensational issues that are everyday issues such as theft, invasion of privacy, data theft, which Tom already talked about, bodily injury, destruction of property. All of these types of risks lead to litigation risk. Liability, coverage, employment issues are all things that insurance companies may need to address in 2016. There's also insurance risks that are more general. For example, with respect to claims, there's data integrity issues. Accidents and claims are being reported under commercial policies and may not be reported to individual auto or homeowner policies. This can result in inaccurate claims data, which could lead to inaccurate underwriting. These tend to be really short-tail trends. These types of risks are really difficult to assess and predict, and you have a very dynamic and changing regulatory landscape. What we're seeing and continuing to see in 2016 will be new products and processes rolled out by insurers. For example, some auto insurers are offering policies that cover drivers as private passengers and ride sharing. You may also see similar homeowners policies. You may see revised applications that focus on questions relating to ride sharing or renting homes. You may also see increased fraud prevention targeting these areas. All these issues and risks make the shared economy something to definitely watch in 2016. But another trend we're looking at in 2016 is autonomous technology in motor vehicles. While everyone may be talking about autonomous vehicles, we aren't quite there yet. Where we are today is that cars are having more and more advanced collision avoidance systems. You're seeing cameras, parallel park assist, automotive emergency braking, lane keeping technology, blind spot assist, and what we will be seeing in the near future is traffic jam autopilot, highway autopilot with lane changing. I think what we will see eventually in the future, and whether this comes in 2016 or not is still an open question, but we're going to see human and animal detection, obstacle detection, auto-to-auto communications, and advanced cruise control in all kinds of vehicles. Why is autonomous technology so important? It really comes down to a safety issue. It decreases accidents caused by driver error, distracted driving, even driving under the influence. Some other ancillary benefits are increased road capacity. You've also got reductions in energy consumption. You've got reductions in pollution, increased mobility for people that are unable or unwilling to drive. And it also could eliminate the need for parking in urban environments. What are some of the disadvantages to autonomous technology? We live in a world where it's possible to disable a car's brakes with an infected MP3 file. This is pretty scary. So there's a risk of hacking, kidnapping, data breach. You've also got technology failures that could lead to accidents. For example, in some recent testing, snow caused an issue with respect to a lot of this autonomous technology. There's safety issues with unintended consequences. For example, when airbags were first rolled out in the 70s, you had testing that was done on dummies that mirrored what an average male was. When they were originally installed, there was it was found that they caused damage to females and children when an accident occurred. These issues are all going to have to be addressed whenever you roll out new technology. It's also got the cost of new technology and the cost to repair this complex new technology. There's a lot of ethical issues that need to be considered as well. How is a car going to be programmed to respond to these ethical issues, such as whether to drive off the road and risk and avoid injury to your passengers, or to hit an object in the road, which could be a small child? These are difficult issues that a car may not be able to grapple with. So what are we going to see? We're going to see some potential issues with respect to how auto insurance is priced. Pricing concerns would include reduced auto insurance premium because there's got to be lower frequency, lower severity, but there's also the potential for costly repairs. Traditional underwriting methods may become irrelevant because it won't matter anymore the age of the driver or the driving experience. Might have a decrease in total losses too. But on the other side, there's going to be repairability issues. But don't worry, insurance is always going to be necessary for fire, rain, flood, hail, theft, etc. So what kind of liability are we talking about when we talk about autonomous technology? We expect that there's going to be new laws, new tort liability, potentially manufacturer's liability. There could be adoption of a no-fault scheme or strict liability with respect to these issues. One of the liability issues that needs to be grappled with is who is responsible for the accident. Is it the car owner, the car manufacturer, the computer technology manufacturer or developer, the dealership? These are all things that we're going to have to address and will need to be addressed in the future. We're also going to continue to see new regulation. And we've got to ask ourselves, well, who should be regulating these issues? What kind of vehicles should be allowed on the road? What kind of testing needs to be done? Who should be allowed to operate them? These are all interesting legal and regulatory issues that are going to need to be addressed in the future. Well, I've only been able to provide a very high-level overview on these interesting emerging areas. I invite anyone to reach out with any questions or thoughts after the presentation.
Thanks, Kim. Next on the agenda is the Federal Telephone Consumer Protection Act, and in particular, recent developments and things to watch as that legislation impacts insurance companies. And for that, our partner Louis Wiener is going to cover that topic. Yeah, while we're resolving a technical issue with the TCPA presentation, late in 2015, we saw some pretty significant amendments to the Federal Rules of Civil Procedure that promise changes in the way discovery is conducted in federal courts around the country, which in our federal system is where so many of in particular the class actions we've been discussing are played out. Valerie Sanders is going to tell us a little bit about those developments.
The word of the day. Thanks, Tom. Just a moment now about the recent changes to the Federal Rules of Civil Procedure, and in particular the discovery and discovery-related rules, subjects undoubtedly many of you have heard about already. The word of the day for these changes probably is proportionality. That's what these changes are all about. We see here on this slide the change to Rule 26B1, which sets forth the scope of permissible discovery, and that underlined language there is new to the rule, effective at the beginning of December of last year, where we've still got the language about, you can have discovery of non-privileged matter relevant to a claim or defense, but we add, and proportional to the needs of the case, considering the importance of the issues at stake, the amount in controversy, the parties' relative access to relevant information, parties' resources, and the importance of the discovery to resolving the issue. And then sort of summing all that up, whether the burden or expense of the proposed discovery outweighs its likely benefit. So that proportionality built right into the rule there in Rule 26. Similarly, as we can see on the next slide, Rule 37 has been amended to try to import a proportionality/common sense scale into the ESI. What happens if ESI is inadvertently and without any bad faith destroyed? And it says now, the rule says, if ESI that should have been preserved and was lost because of a failure to take reasonable steps, it can't be restored, then we see number one, there can be curative measures directly married to the prejudice shown by what happened. And number two, we're only going to get the more draconian sanctions of dismissal, default, adverse inferences, etc., upon a finding that the party acted with the intent to deprive another of the information. So again, it's proportionality in the sense of having the punishment fit the crime, if we could call it that, there in Rule 37. Some other really more housekeeping changes to Rule 34, although one gets a little more substantive. There's a set rule now that if requests are served before the 26F conference, they're due 30 days after that. No +3 there, just as a practice pointer. It also states, the new Rule 34, that two things that are a little more substantive. The first one, the objections must be specific, and the responses must state whether documents are actually being withheld. I think a lot of us have grown up making objections which we might need in an abundance of caution, but we don't really have in mind documents that we're withholding. So that's designed to sort of flush that out and maybe minimize that kind of thing. So there may be one more slide on this, but in general, and there are good ways to find sum up of these rules, in general it's all about proportionality. We'll see how much it changes the practice, but definitely a new line of defense to what we might consider overreaching discovery requests.
Thanks, Valerie. And the final topic we want to cover today, we are now going to cover the Federal Telephone Consumer Protection Act, and our partner Louis Wiener is going to speak on that topic.
Thanks, Tom. How ironic to have a communications problem when we're talking about telephones. I would suggest that there's probably not a person participating in this that if you look down and your right hip didn't have some type of cell phone or PDA hooked onto your belt. It's the ubiquity of cell phones and portable communication devices that has made the Telephone Consumer Protection Act probably one of the most powerful, omnipresent consumer protection statutes of the current era. The TCPA, as it's commonly known, prohibits telemarketing, most specifically to cell phones, and requires consumer consent for the use of automatic dialing systems, pre-recorded voice messages, those are the robocalls that we all love to get, text messages, and faxes. To be clear, the TCPA doesn't prohibit communication for marketing purposes to cell phones, it regulates it. And what it says is the consumer, us, have to provide consent. And the type of communication that we receive has to match with the kind of consent that we have provided. If the two ends do not meet in the middle, there lies the TCPA violation. And TCPA imposes statutory violations of $500 per violation, that's per call, up to $1,500 treble damages if the conduct is deemed knowing or willful. And most significantly, there is no cap on damages. To put this in some perspective, in 2015, the top four, just the top four settlements in TCPA cases exceeded $150 million. Let me repeat that, $150 million based on conduct that's calculated at $500 per call. You can do the math and find out and figure out very quickly how damages in TCPA cases, given the omnipresence of technology and how technology has permeated our communication, makes the TCPA a very powerful tool in plaintiff's counsel's hands because calls are being made at an incredibly rapid rate. What are the implications of the TCPA for the insurance industry, and why should you care? First, TCPA cases have been, for the last 3 years running, the second most filed type of case in federal courts around the country. So of all the cases, of the types of cases filed, TCPA cases have risen to number 2 behind only wage and hour cases. That means there's an awful lot of cases being filed. And who are they being filed against? They're being filed against the insurance industry, among others. But why the insurance industry? It's because you all have 3 levels of potential liability. It comes from 3 places. First, it's insurance companies interact directly with their insureds and potential insureds. There's home office contact. There is the constant communication that goes on between the company and its insureds. And not all of that contact involves marketing. Not all of that contact implicates the TCPA, but there is enough contact on enough of a regular basis involving enough people that the TCPA does get implicated at regular intervals. You also have the issue of third-party liability, contact through agents, representatives, brokers, etc., that are acting on behalf of the insurance company. That's a potential avenue of risk and liability for the company because of the acting on behalf of angle. Third, you have the claims of your insureds. Your insureds are out there involved in conduct that implicates TCPA liability. And those insureds are then seeking coverage. So between the company's own conduct, the conduct of third parties, and the conduct of your insured, those are 3 avenues that give rise to potential liability under the TCPA. The TCPA covers both conduct of involving calling, faxes, and texts. What you see on the screen is what we call our TCPA traffic light. And we'll be glad to provide a copy of this to anyone who's interested. Just you can shoot me or Wilson Barmeyer, who spoke earlier, an email. Give us a call, and we'll be glad to send you a copy of this. And what we've tried to do here is, in very simple terms, the traffic light, yellow, red, green, display what the rules of the road are. You'll see it's divided between calls made to landlines and cell phones across the top, further subdivided between marketing calls and non-marketing calls, and then on the left side, running down, the type of communication, auto dial, robocall, manually dialed calls, or faxes. We use the term call and text interchangeably. When the TCPA was enacted in 1991, there was no such thing as texting. Today, texting is one of the most common forms of electronic communication there is, even surpassing email. But what we've tried to show here is, so if you're making a marketing call to a cell phone using an auto dialer, there's a red box, stop. And what that tells you is that you need to stop and do something before you can proceed. And what you have there is prior express written consent. There are 2 types of consent that are required in order to communicate with individuals by cell phone. Prior express written consent or prior express consent. Written consent, which is the highest form of consent, is required for marketing. Non-marketing requires express consent. What's express consent? If someone gives you their number, they have to anticipate that you're going to use it and call them. That's express consent. Written consent is the highest form of consent, which is required for marketing calls. The green boxes, you're good to go. The yellow, caution. And what's in the yellow? The do not call list. one of the features of the TCPA enacted in 1991 is the federal do not call list. If you don't want to call, you can register and say, please do not call me. There are certain exceptions to that that extend to existing business relationships that we won't go into now, but you need to be aware that is the company's obligation to monitor and maintain the federal, state, and company-specific do not call list. Turning to the next slide, best practices and recommendations. The FCC, which has principal jurisdiction over the TCPA, in July of 2015 came out with an order that attempted to address a number of open TCPA issues. Among them, the definition of auto dialer, revocation of consent, and the intractable problem of reassigned cell phone numbers. We have incorporated that into our best practices and recommendations. You have to be able to allow your customers and potential customers to opt out, to say, I don't want to get calls anymore. We recommend to our clients that you adopt policies and procedures that allow you to efficiently and effectively record opt-outs and make sure that that information is communicated within your organization. It's a challenge, given how dispersed and decentralized a lot of communication programs are and a lot of companies are. But nevertheless, the FCC requires that you afford customers the opportunity to revoke consent by any means possible. It's also important to know that consent runs with the customer, the individual, not the phone number. That implicates the problem of cell phone reassignment. The FCC reported in its July 2015 order that as many as 100,000 cell phones, let me repeat that, 100,000 cell phone numbers are reassigned in this country every day. That's 3 million numbers a month. 1 month, 36 million a year. It is very difficult for companies to keep track of who the current owner of a cell phone number is. And because consent runs with the customer, not with the number, the FCC has opined that companies are allowed one free call to determine who the owner of the cell phone is, whether or not that person picks up the phone. It's frankly an absurd rule and has been challenged in the courts. You can see some of the other best practices and recommendations that we have. Again, what it comes down to is use common sense. You don't want to be the defendant in the case where someone is sued for violations of the TCPA because they were called 282 times with a number of those calls coming after 9 o'clock at night. The curb appeal of that case from the plaintiff's perspective is high. Use common sense. Let me end with one other cautionary note also related to communication. An issue that we are on top of that we think is in its infancy but poses potential risks to insurance company is that of the ADA, Americans with Disabilities Act, and website accessibility. The ADA requires that all places of public accommodation be ADA compliant and provide access to people with disabilities, in this case the blind and sight impaired, that they have access to places of public accommodation on terms equivalent to the non-disabled. There have been a number of courts and an increasingly number of courts that have said that web pages are places of public accommodation and therefore subject to the requirements of the Americans with Disabilities Act. We have handled one of the seminal cases in this area, one of the few cases in this area, addressing the issue of website ADA compliance. We think this is an issue that's coming down the pike and hope that you'll stay tuned for more information and our updates on that topic, as well as developments in the TCPA. Tom, let me turn it back to you.
Great. Well, that brings us to the end of today's webinar. We would like to thank everyone for joining us, and we hope that you'll join us for upcoming presentations in the series. And a reminder, there is CLE credit available. Please just download the CLE sign-in sheet and evaluation form and follow the instructions for submission. And should you have any questions about today's topics or the series, please feel free to contact any of the speakers.